Binaya mı gidiyor? Burada içeri doğru gidiyor. Maden. Orada bir şey var. Aha.
Öyle bir bulmuşlar mı? Var mı bir ibare? Şu anda bilgim yok. Sarı.
Gelip kolay gelsin.
A new ash advisory has been issued for the Fuego volcano, Washington Center. Ongoing volcanic ash emission moving west.
And when that service is met, I will call Mr. Padilla. I'm telling you as an officer of the court, I've never misled anybody in any courtroom, in any county or any nation, in any state. I will call Mr. Padilla upon that effectuating proper and good service and work something out with Mr. Padilla. But the order to show cause cannot be entered based on what is attached to that motion and based on the lack of what is filed in the court file, because even the dates are incorrect. So if we're going to enter an order to show cause, I understand the argument I can make at an order to show cause. But these aren't even arguments to be made in an order to show cause. These affidavits, the order to show cause shouldn't even be entered, is what my argument is. The arguments to be made at the order to show cause are, this guy who showed up and buzzed on a buzzer and said, "Oh, who's there?" There's a guy named JJ, and he says, "Okay, I'm going to accept service," which there would be testimony that this is not how it went down. But the affidavit is, "I'm here to serve Mr. Graham with a deposition. Will you accept service?" And some random guy named JJ on an intercom says, "Yes, I will accept service. Please put it in the mailbox at the end of the driveway." Makes little to no sense. But that would be my argument at the order to show cause. My argument here is that these affidavits that are filed are insufficient to even enter the order to show cause. So I'm asking the court to set aside that order to show cause. It is of no consequence to Mr. Padilla if that gets set aside, because he's going to have to serve this anyways. He's going to have to serve it for a deposition. So let him serve it for a deposition. If and when that service is effectuated, I will call and I'll work something out with Mr. Padilla to figure out what we're going to do if the service is good. That's my proposal, Judge. And I'm sure Mr. Padilla, knowing Mr. Padilla, he doesn't like that, but that's my proposal.
So, Judge, he's spoken a lot, but one thing that he hasn't said is that he will accept service for Mr. Graham. because he will not. And if the
No one
affidavit-
said.
and if the affidavits were insufficient, and if it wasn't enough, this court would have never executed that order. And I understand his arguments, but they're just trying to prevent my client's due process rights to move forward with the deposition. And I appreciate the court saying that it's gonna narrowly tailor the issues discussed, and that's it. I don't understand, he keeps reiterating, if this court would have never executed that order if it didn't happen.
All right, well, I have some disagreement with Mr. Cohen as to whether or not there was enough to issue the order to show cause. But whether or not it's appearing at the show cause hearing to present these defenses as to why one should not be held in contempt, or if it's brought beforehand, the court listens to it either way. And I think if these things were presented at the show cause date, probably sufficient for me to say, okay, this isn't a attempt to knowingly just disregard the subpoena, but that they have their view as to whether or not these are properly served or were done properly. So at this point, I will set aside the show cause order because I think it's been answered. But what I've told counsel, and counsel at least seems receptive to, is there's a certain amount of wheel spinning that goes along.
I get it.
We can continue to try until we get it perfect. At some point, they will, or Michael.
Oh,
But
I know Mr. Padilla, he will.
he will camp out at that game when JJ walks out there. He'll say he's over it. If he still even works there.
Mysterious JJ.
But
Yes.
the bottom line of the thing is, if we're going to make this happen, let's make this happen. Let's do it at a time that is the most convenient to your client. Let's schedule, that time again. The time that's most convenient. Counsel's available. Everybody's available to do it. And like I said, I don't intend for this to be used to harass your client in any way, and for that purpose, you can rest assured that I'm not going to allow this to be splashed all over and look at Greg answering questions and that sort of thing, because that's not the purpose behind this. So I can give you that, and
Yes, sir.
and he can effectuate his
Service.
diligence to have fully investigated for his client. And I mean, in the end, if your client feels that this is all done just in bad faith, well then, he's got a remedy for abuse of process, and that's a whole nother realm. That's two stages beyond this.
We will discuss. Judge, can we have a short order on the order show cause? And and then.
You want a short order? Would you
Yes.
rather prepare one?
I'll prepare.
Typed up
I'll
and
type one.
submitted to Chambers?
Yeah,
You've
I'll
got
type one.
the whole rule now.
And then.
And I am asking that, as part of that, dismissing that you make a good faith attempt
I will.
to discuss with counsel how we might effectuate this in as easy a terms as possible, to not waste everyone's time and resources.
I will. Okay, and then also, Judge, do you want me to type up an order limiting the scope, or do you want defense to type up an order and then have me
Well,
review?
probably you want to type it up and show it to him.
That's what I would.
submit it,
Yeah.
But something consistent with what my ruling is.
Okay. Cool. Thanks, Judge.
All right,
I'll get that to you.
thank you.
Thank you, Judge.
Yes, next.
Morning again. As to the second matter, on Friday, Mr. Padilla cross-examined Mr. Allen regarding a variety of things. I asked for the transcript of the cross-examination to be expedited. I have not received the final one. I only received a preliminary one. However, with respect to what I did receive, Your Honor, I wanted to point out a couple things because I believe under the case law of Bozeman, B-O-Z-E-M-A-N versus state, and Simmons versus, well, Bozeman is cited at 698, Southern Second, 629, and I have copies for the parties. May I approach? Thank you. Under Bozeman, which is a 468 case, cited Toronto. It goes on, where he then is asking about the person, and this is important, it says 8 on the page.
Yes.
Actually, you want to shield people from this case like you did shield with the individual in the car that picked you up. Isn't that true? And from the context of that questioning, based on what was asked during direct, I believe that's referring to when Mr. Allen entered the car, a sedan, a gray sedan, where a female flagged him down and he entered the back seat, and he testified about that. There was a lot of trepidation from Mr. Allen to identify who this person was. First, initially on Mr. Kimmock's questioning, Mr. Kimmock asked him, and it appeared that Mr. Kimmock took the cue for Mr. Allen not to go further because it could violate some pretrial rulings. But instead, Mr. Padilla kept going and needling the point to say, well, so you're testifying that the person has nothing to do with Toronto, which is the misleading part, that the person picked you up. I objected, and as you can see, Your Honor, objection. So Mr. Padilla kept going and saying, you're refusing to identify the person. It had nothing to do with Toronto. Answer, she doesn't have anything to do with Toronto. He then goes on, talks about how the guns in this case, or asked the witness if the guns in this case, there was some nefarious reason as to why they were supplied. First, outright asking improperly that the person who supplied the guns was the father who sells cocaine and is dealing with people in Toronto. Again, that was denied. Then he asked, well, wasn't the person murdered that provided your these guns? Again, that was denied. Wasn't your stepfather murdered? No. All of these things collectively, and I have more to point out, were done in a way to mislead the jury that these were items that were connected to the defense, which I believe he's trying to put together to say that somebody in Toronto or Drake had something to do with this without any evidence of it. Then he goes on to say that he asked about him being a drug addict, as if that had something to do with it. That objection was sustained, and the jury was instructed to disregard. But then he goes on, and I don't have the page number. Let me see what's the nearest page number that I could reference the court. It's after what is page 15. It says 15 on the page to the very next page, not numbered.
Okay.
Mr. Padilla asked about if the witness was in a sexual relationship with the witness who the jury will hear from, Ms. Robinson, and about her testimony, and then goes on to say that the reason that he was calling her every day was because they were friends or there was some type of sexual relationship, when in reality, the reason why Mr. Allen had been in constant contact with Ms. Robinson is because she was renting cars for his client to rob people. And that is an incorrect assertion, misleading to the jury, that we, the state, are entitled to rebut at this point, is what I'm arguing. Additionally, Mr. Padilla goes on to say, on that same page, about, and actually Mr. Allen answered that question, so it's left out there where he says, I was calling her every day because we were renting cars to rob people. Then he says, were you doing that every day or every other day? It says every single day. Then he goes on, so your testimony now is that every single day, correct? Just about, yes. And then they go on into the frequency of how often this was done. Then Mr. Allen answers through Tony, through Michael, through Dietrich Williams. 2 pages after that, Mr. Padilla continues on asking, well, what do you need 4 cell phones for? And explain that to the jury. And then I'm going through my points. There's so many, Judge. I'm going through my points.
What are you saying the door is open to?
Okay, so nearly after that, the witness is asked about committing the fraud and the robberies. I would argue that committing the robberies has been open because that is misleading to this jury as to why the frequency that he was contacting a particular witness. Also the motive and the intent of that the state has to prove as to Mr. Williams, that there was an intent to rob the victim that day because he'd done it numerous other times. Ordinarily, this wouldn't be testimony that the state can get into, but Mr. Padilla opened that door by trying to create some misleading facts that this had something to do with a rapper in Toronto, people connected in Toronto, a drug dealer dad, a sexual relationship, none of which there's any evidence for, none of which is true. It's actually categorically false. And the state can prove that it's false by rebuttal evidence regarding that. Additionally, Mr. Padilla went into, towards the end of his very abrupt ending of his cross-examination, why the witness is in protective custody, why the witness would be in fear of his life, making it seem as if there's some type of other reason, that there's some other nefarious actors or characters connected to this case that are responsible for that. When in reality, it's his client that's responsible for this witness to be fearful. It's his client that's responsible for this witness to be in protective custody. It's his client that's in a gang that's been threatening this witness's life. And so now what the jury is left with is that there's some impression or some evidence that does not exist, that there's some connection to Toronto that he received, Mr. Allen received to do this crime, and that he's in fear because of that. Nothing is further from the truth. That is misleading to this jury under the case law. And the reason why I was pointing out all the instances that Mr. Padilla did this is because it was an intentional act on Mr. Padilla to try to mislead this jury. After so many sustained objections, after so many sidebars, he still kept doing it. And so I would argue, Judge, that we then have a right to rebut this evidence because the door has now been opened as to Mr. Williams. And Your Honor will recall, when that last inappropriate question was made by Mr. Padilla, it was so inflammatory that Your Honor gave an instruction to the jury that they should disregard it as to Mr. Boatwright and Mr. Newsom, because Mr. Kimmock, on behalf of Mr. Boatwright, hadn't opened the door, and Mr. Ramirez, on behalf of Mr. Newsom, had not opened the door. It goes without saying that the logic is Mr. Williams, his client, or his attorney, had opened the door, because Your Honor did not instruct the jury as to Mr. Williams. And so now that's left out there, that potentially Mr. Boatwright is not involved with gangs, Mr. Newsom is not involved with gangs, but they can consider that answer can go to Mr. Williams. So I'm asking to correct what is misleading facts that have been left with this jury. And I think that the case law says that in the court's discretion, it would be appropriate and proper to do so.
Judge, first of all, I want to start off by saying that I emailed all state attorneys and I asked them for the case law that they were assigned today. They didn't give it to me.
30 minutes ago, Judge. I want to point that out.
Judge, there's a huge discrepancy in the way that she's presenting what occurred and what actually occurred. What actually occurred is that the state's cooperating witness, while testifying, in a deposition in December of 2022, when asked, who is the individual that was in the car that picked you up, said, I don't know. Fast forward, under direct examination with Mr. Kim, under direct examination, when asked by the state, who is that person? I don't know. Then all of a sudden, the next day, when Mr. Kim asked, I don't think you want me to answer that in front of the jury. So the persistence, and the only thing that really matters in that transcript is how I was scrutinizing the state's cooperating witnesses' response or his inaccurate statements. He went from, I don't know who it is, to, in one day, I'm afraid that person's gonna kill me. And as a defense attorney, I have every right on behalf of my client to get into how does that change from one day to the other. And that's what I was doing. And I did not open the door. I believe, and I don't have the benefit of having read the case law that she cited to you, but I'll tell you right now, I know what I did, and I did not purposely open any door. I was simply doing my job. Now, regarding the issue of gangs, Judge, this is a constant sword and shield for the state. They have, through the entire time, said this is not a gang case. They didn't charge it as a gang case. However, everybody involves a gang, and my guy's the leader of it. And every single time that I do anything, I'm tiptoeing through a field full of landmines. If I ask, why does Leonard Kerr, a Lyft and Uber driver, have the money to have two security guards here? Oh, I opened the door. Everything that I do is now opening the door. She's the one that didn't charge us as a gang case, and that was apparently, that's her decision. But now every single thing that I do on behalf of my client is I'm opening the door. Now, she actually, when I asked that question, and if you look at the transcripts, look at what I asked. Are you in fear of your life? Yeah, yes. And then that's when he says, they're in a gang. They're in a gang meeting. I'm asking about the identity of the person that's driving the car. That's what I'm talking about. And that's what he said. That is not opening the door. That is not opening the door. So she goes sidebar and now says that it's a concerted effort by all of us to force him to say that. And I'm here to tell you that if it's any concerted effort, it was a concerted effort by the state because that's their own witness. So a couple of options could exist. Number one, they failed to properly prepare their witness. Because if they would have known that the identity of the witness was gang related, she could have done a motion in limine to prevent it. Number two, it was on purpose. Obviously, I'm hoping that it wasn't, but I have to make that argument that it could have been on behalf of my client. Or that Robert Allen is a liar. That's changing his story from one day to the next. And that's simply all I was doing, Judge, on behalf of my client. So everything, I feel like if everything that I say, Mr. Allen was, Mr. Allen says that my guy told him to do it. Well, isn't it true that you told my client or you were chauffeuring my client around? Every single thing I feel that they're going to argue that I opened the door. I don't think that I opened the door. I don't think that anything that she stated to the court is a grounds for the court to open the door to the detriment of my client. And the fact that the state's own witness is the one that apparently, after being prepared and after being admonished not to do it, said they're in a gang, I have to move for a mistrial on behalf of my client.
All right, thank you. So,
Oh, sorry, Judge, I have one more thing. Sorry. And regarding the fraud, if the court looks at the transcripts, the state's own witness is the one, when asked, why do you need so many phones, said, oh, because of fraud. I didn't open that door. He's the one that said it was because of fraud. Sorry.
I have a few concerns on behalf of the people, right? So I would just seek clarification from the state as to exactly what facts that it seeks to introduce to Mr. Allen, that it believes the court has been open, so that if there are any issues regarding Mr. Boatwright, I can address them now, as opposed to having those facts be out there. Obviously, we have Mr. Boatwright, we don't have a position as to Mr. Williams' gang activity or as to Mr. Williams' prior involvement in robberies. I would object to any of that testimony coming in regard to Mr. Boatwright.
And I would join on behalf of Mr. Newsom and ask for any clarification regarding whatever the state feels may inure to the detriment of my client based on the cross-examination by Mr. Padilla. I don't see anything. I appreciate the court's curative instruction. He's right on point.
all right. A lot of different things that are mixed in here. The questions that were asked where objections were sustained and jury was told to disregard are not going to be used to open doors. When the court orders the jury to disregard, it's disregarded. When the objection is sustained, it's sustained. So that kind of ends that. Secondly, there were a number of questions questions that were asked that were of that there's no, at this point, nothing in the record that shows the basis. Were you paid by, someone else? Are these orders coming out of Toronto? They said no. I don't know what you're talking about. I've been to Toronto, okay? It is incumbent upon the parties, or the state, or whoever, to remind the jury that what the attorneys say is not evidence. The evidence is from the stand. So, counsel gets up there and says, little green men from Mars came down and did this, and the witness says no. That doesn't mean there's evidence of little green men. The evidence is no. Okay? So, that takes care of that. With respect to, again, opening the door on the game thing, that objection was sustained. The jury was given a lengthy curative disregard. I didn't tell them in disregarding that they should consider it against Mr. Williams, but I went out of my way to make sure that they did not consider it against Mr. Newsom or Mr. Fulbright, because they had not caused the controversy, so it was the court's feeling that they were entitled to additional extra protection, where the protection of them just to disregard the question and answer and the lengthy curative was enough to take care of that. It does not, therefore, open any doors. You don't open doors when the court sustains an objection and tells the jury to disregard it. No, I can't unring the bell, but that is the legal equivalent of saying it is as if it did not happen, you are not considered. Okay, so that certainly doesn't open doors. As far as why'd you call this person every day? We were committing robberies. I guess it's up to them to decide who the we is in that. We have a lot of rules which insulate defendants from having the case decided upon, not upon the facts involved in a particular crime, but that we insulate them from having jurors make decisions based on prior acts. This is all based on the American system of justice, that we know human nature is, if someone's been convicted of burglary 7 times before and they're accused of a burglary, jury might say, yeah, I kind of think they probably were. So we don't let them know that. And a lot of people look at it and say, that's kind of unfair, they should know that. No, because the charge in a particular burglary case either stands or falls on its own evidence and not on that person's propensity. Should they be convicted, then the judge is in a position to say, you're an 8-time loser here, and definitely consider that. But the jury, in deciding whether or not the presumption of innocence has been overcome, is based on the facts of the case that you have and not to be drawn in by this other stuff. While Mr. Padilla may have come very close to opening doors, and he has his own reasons for going into areas that he goes into, I have the obligation to make sure that error is not committed by allowing something in and doing a balancing test. I don't see getting into the side issues of what robberies they've committed together in the past. We're not going to go there. Had he not asked those questions, it would still come out that Mr. Allen's a 12-time convicted felon, although I think it's, only 2 cases, it's 12 counts. That can be clarified on redirect if you think it's been misrepresented, but he was quite candid with the jurors as to what he had done before. And I don't think he was trying to hide it, and I don't think that was improper. I don't think that opens the door to every misdeed that any of these particular defendants may or may not have engaged in the past. That's why we don't typically allow it. And I that I'm gonna allow you to get into that or to ideas about game things. I think it's well clear from Mr. Allen's testimony that he is frightened of retaliation. Whether or not a person's in a game or not, doesn't make that fear of retaliation any more or less strong. His testimony that was not objected to or that was not, jury was not told to disregard is that he is in fear. Okay, so that's out there and you have that. As to the two cases that you presented in court, once again, I remind all counsel to understand the difference between a appellate court saying this is what you should do and an appellate court saying that a judge did not abuse the judge's discretion by allowing something to happen. Those are two different things. And in this case, in these cases, the appellate court said that the judge did not abuse discretion by allowing it in, but I don't know that they stand for the fact that the judge should have and ought to have, and all judges in the future should. They're merely saying we don't think that it led to error here. And I would also tell counsel that bringing cases like Simmons where the appellate court uses its coachman doctrine is not one that the court usually wants to follow because it's essentially saying, well, the judge's reasoning wasn't all that good, but he got to the right place somehow anyway. And so I don't find those to be overly on point or persuasive to the court. So I do not find that the door has been opened on these things. Objections were made, rulings were made, either abstaining or overruling, and a clear bill was given. That's been set. Ms. Butler, you have something as well?
I do, Your Honor, yes. Alexander, on behalf of the state. Before I begin, I will handle that case off the counsel.
Briefly, before she starts, Judge, could you just roll on the motion for Mr. Lauderdale?
I kind of already ruled
No,
on
that's
that sidebar before it's denied.
Okay, no, in the sidebar, I didn't join, I just joined now for the first time, I just wanted to recognize this.
Okay, it's denied, you can't create your own error.
Thank you.
May I correct, Your Honor?
Yes.
So, Your Honor, my argument is based on the evidence rule of prior consistent statements. As we have seen throughout Mr. Allen's testimony, he has been attacked on all fronts as to his truthfulness and to why he's all of a sudden being truthful in his testimony here today in front of the jury. Based on that and the attacks that have already come out from Mr. Kima and Mr. Padilla, and I assume will be coming from Mr. Ramirez as well, we would ask that his prior consistent statements, at least portions of it, do come in at this point when we, start our redirect. So the case law obviously is very clear. There are several exceptions to the general rule that are listed in section 90.8012B of the Florida statutes, and it provides that a prior consistent statement is not hearsay if it is offered to rebut an express or implied charge against the declarant of improper influence, motive, or recent fabrication, and if the witness testifies at trial and is subject to cross-examination. So for the record, I'll just put the cases on there. It's Monday v. State, 792, Southern 2nd, 1278. It's the first DCA case from 2001. Then there is Rodriguez v. State, 57, Southern 3rd, 961. It's a fourth DCA from 2011. And then there is a Gibson v. State, 320, Southern 3rd, 245. It's a first DCA case from 2021. I also just printed another case, which I can email everyone, but for the record, it's Valentine v. State, 307 Southern 3rd, 726 from 2020, the fourth DCA case. And as Your Honor is, I'm sure, very well aware of the rules of evidence of this, I won't go through each case and the facts, but based on the fact that Mr. Allen was attacked on his truthfulness and potentially not being truthful here today in his testimony because he got a plea deal, we feel as though his prior statements should come in. I am not asking for his deposition to come in because obviously that was taken after he already took a plea deal. But I am asking for the other statements or portions thereof of each statement to come in to rebut that issue of he's not being truthful now, he's only telling the truth because he got a plea deal.
Go down the line.
It's hard to respond without knowing exactly what quote unquote prior consistent statement the state seeks to abuse, I would point out that we very explicitly argued that Mr. Allen testified to this, that he'd been trying to attempt to get a plea deal very early in the process. And so any reason or motive to lie happened very, very early. If the state thinks that it has statements that predate that, then, we may have a different discussion. I would like to see what those are. But without knowing explicitly what statements the state believes are prior consistent statements, there's not much that I can do at this point. But I generally object until we know exactly what those statements are.
Judge, I would join on behalf of Mr. Newsom. I'm not quite sure what the state's referring to. Obviously, I strenuously object that portions of any statement he gave previously not be picked out, because the sum total of all those statements were, he lied in every one of them. So if the state wants to introduce all those prior statements as they sit, I think that'd be fair game. I'd love to have that in front of the jury. But just illustrate the point we're making is that he's still not telling the truth.
Join Judge, on behalf of my client.
All right, so,
Your Honor, if I may just respond quickly to that, is we need to go through each transcript to decide which portions would come in and which would come out. I'm specifically only going to go after things that he was attacked on, to not overburden the court of just replaying his entire testimony. That's what the case law says. It's not just to be repetitive. It is to now show that in fact this predates any bias that could be alleged. Additionally, the case law is very, very clear, so I don't know why Mr. Ramirez is arguing this, that the entire statement should come in, because the cases I provided, the cases that exist throughout this particular hearsay exception, describes only putting in the portions that now rebut the impeachment or the lies or the reason for why he might not be telling the truth now because of that bias or recent fabrication or motive.
all right, thank you. So I appreciate the cases that were presented again. This is pretty well settled area of law, and the rules of evidence conflict. So where a witness's credibility has been attacked and the question is raised as to whether or not this is a recent fabrication or it is the result of some promise or benefit or that type of things, then prior consistent statements can be admissible. And the idea behind it is until someone's credibility is attacked, you can't say, see, testifying now, and you continually said this throughout because now that's improper bolstering. But once they've been attacked, then you can bring it in fairness to clarify things. So where the questions were asked, well, you changed your story on this, or you lied about this aspect, I think it is fair game to say in these earlier statements, and I haven't read the earlier statements, they're not in front of me, but in earlier statements it said, yeah, the four of us did this, and things that have not changed, I think are fair game when the questions that have been put out there is, oh, everything you said before is a whole pack of lies, and now you come in with this new thing. The material areas that were consistent before, I think are fair to come out, and to explain changes, I think is fair. Again, in terms of door opening, when you cross-examine and you raise these questions, and I think they are raised in a matter of you've changed your testimony in order to get a benefit, that the state is entitled to bring in evidence that no statements consistent with this were made prior to that. Okay, and that although some things have changed, overall tenor of the story has remained the same. Some details have changed. Those are fair areas of getting at this. We wouldn't let them do it before being attacked on it, but we've certainly been attacked by at least two of the council on those points, and it'll be up to the jury to decide what weight to give that. But I think this is proper.
Clarifying, the alleged motive to lie, that we said was the motive to lie is because he was attempting to and then got a deal. He has testified that he was attempting to get a deal as early as the October 2018 statement. He was attempting to get a deal in the July 2022 statement, and he's attempting for a lesser sentence here before the deal. And so, to the extent that the state is seeking to introduce any statements from the October 2018 interview or the July 2022 interview, we object because anything that was said during that time does not predate his motive to lie. To the extent there's anything that predates October of 2018, then I think that I would like a chance to see exactly what it is that the state wants to introduce, and I can, make any temporary suggestions.
I understand your concern, but I think this is an ongoing thing. Again, I have not seen the earlier statements, but it appears to me from the testimony that has come out that Mr. Allen essentially was attempting to minimize his involvement at first by saying like, well, I didn't know there were guns there. And then later on, he said, all right, so I knew about that. And that a lot of the changes and the lies that he has admitted to appear to be him minimizing his own involvement as opposed to changing the involvement of others. And I think it's fair for the state to point that out. So that's my ruling. I will listen for contemporaneous objections. And I mean, we still have another cross to get through, but I think on redirect that the prior statements have been attacked to the point that the state is allowed to rebut any inference of that it was done merely to in furtherance of this deal or that it's recent application.
Well, I certainly object to any statements, any prior consistent statements whatsoever coming in that do not predate the defendant's, or excuse me, the witnesses, Mr. Allen's motive to lie, which he specifically indicated he was trying to get a deal as early as October of 2018.
I understand your question.
So, Your Honor, for purposes of, I guess, scheduling with Mr. Allen's testimony, because obviously I could not really even go into this until at least a substantive amount of cross-examination has occurred. Now that it has, we're going to have to obviously go through each statement and then redact it from the video that we would then play in front of the jury. I know we still have Mr. Rivera's cross. I know Mr. Shields still has to be redirect, and we could potentially do this over a long lunch today so that we can get that done. So then during Mr. Shields' cross-examination, it's ready to go. I'm sorry, redirect. I do have copies for Your Honor so that you have it of each statement. So if I can approach and just give those to you now. And I don't know if that's the way that Your Honor wants to go about doing things, but that might be the most efficient way to do things.
Doesn't hurt for me to have copies.
And it really sounds like we're asking for an evidentiary hearing in the middle of the trial at this point. Based on your ruling, we may want to go through those transcripts themselves and determine what else we can ask questions about. All in the context of being very careful not to open doors with landmines everywhere. It's going to be tough to squeeze all that in a lunch hour while this is going on.
Another alternative, Judge, we have two additional witnesses that we can put on today, and I can take my redirect out of turn. I mean, the witness is gonna be available. Your Honor is scrunching up his face, so maybe that's not a good suggestion.
Well, I don't know that. I'd have to see how the parties feel about this, and I would not necessarily have, I don't know that they want there to be a break.
Okay.
And then, you have Mr. Harris, and then there's a break, and then you come back a day later, and when things are even less fresh, although if the parties are in agreement to do that, take the two out of turn, so we can look these things over, and then Mr. Harris will have the opportunity to do the cross on the following day, and then you redirect, and then any recross, if everyone's in agreement with that, I'm okay with it. I don't know that I want the defense to be done and then there to be a day break before you get your chance to redirect.
break now?
I'm saying, yeah, we would just go with the other witnesses now, if that's what
I
you
don't
want to
agree.
do.
Okay. And the witnesses aren't gonna be available at 1 anyway, so they're not here just quite yet.
We have a moment, for judges, as counsel, perhaps, yes, John, you outside yourself, over a moment. Sure. Necessary to address this.
No,
They're still in reception, yes.
These are the three pictures that are allowed, that are incorporated in the protocol.
yeah, they need to be marked. Yeah, no, well, they were offered as with the record.
Right, look.
in speaking to defense counsel, and trying to come to a consensus on how to proceed regarding perhaps taking witnesses out of turn and keeping it moving. We do not, the defense, all three do not agree to that, so the other alternative would be, I think, something we all agree on, which is not perhaps the best, most enjoyable course of action, but I think we do need an opportunity to review all the transcripts they just handed you, which we didn't get copies of.
Fair enough.
Look at exactly what they're trying to get in, get some rulings, so we don't have to be popping up and having other line items blowing up. And then proceed forward at whatever point in time that works best for all parties. Your suggestion is to,
Your Honor, just to be clear, they already have all these transcripts, they were provided in the discovery, but
I always want to see what you.
I
same
understand,
exact ones we
okay.
have. But I think we are in agreement that if Your Honor does not want to pause after the cross of Mr. Ramirez and then do this hearing and go through the transcript and then have Mrs. Shield do her redirect, then I think what Mr. Ramirez is saying is probably us pausing for the day and.
Yeah, so here's what I said I don't want is we move on to other witnesses and then come back to redirect. It just, for whatever primacy and recency things, I think they need to be stick together. So I think it's fair. I trust that the jury will be understanding. I mean, they know this is a long trial and things are going on. What I would like to do is, so that, what I don't want to have happen is that you guys go through all this and the state makes its things, and then you do your cross and they say, oh, there's new stuff, right? So let's get your cross done, okay? Then I'm gonna tell them that we were going over some things this morning. We wanted to do this as part of the testimony. We're gonna recess them for the day. You guys can take an extended lunch, whatever. We'll come back sometime later in the afternoon, flesh this stuff out. First thing tomorrow morning, redirect. I think that's the best way to do this.
No problem. Judge, if I could, Miss Buckaloo will stand in, continue standing. I just want to call those two civilians that were gonna come in at 1 and just tell them no for
You
today.
can take a second, we'll do that. And but you wanted to say something?
We're fine.
Okay. All right, so,
Judge, I'm sorry, just one more issue that I wanted to mention. So the other day, I have my two investigators in the back there, and counsel here, I spoke with everybody. While I was finishing my cross-examination, Ms. Buckaloo was hitting the table, and then Mrs. Shields leaned back in her chair, pointed. Then when we went to the sidebar, Ms. Buckaloo is basically making facial expressions, and the jury's right there. So I would just ask the court that everybody maintain facial neutrality and not, and limit the dramatics because the jury's watching. And I just wanted to mention that now. Number one. Number two, Judge, in the future, if they're gonna hand the court something, I would really like a courtesy copy of whatever they're gonna hand the court. Move forward.
Again, Judge, they have those copies of the transcripts. They were referring to them in their cross-examinations left and right. So those are the transcripts that I referred to. As for facial expressions, I don't recall any facial expressions I made, and if I'm sidebar, I'm looking at Your Honor, I'm not looking at the jury, so.
I will expect all counsel to report themselves.
I understand what you're saying regarding, we may have it, but still, I believe that if anybody hands the court anything, they're obligated to give a carbon, exact copy to the other side. Because I don't know what they gave.
I think if you already have it, you already have it. The court indicated it does not have copies of these previous statements that, as counsel indicated, you made reference to, and she's handed me, so. If they're there, I think you can say, Judge, I'm providing you with this, which was, the statement on such and such a date, which was turned over in discovery, the other statement on such and such a date, so at least they know what it is, but I don't know that they need to burn off an extra copy, 3 extra copies of everything if you were previously provided discovery, so that's that. Where's the do it?
I guess so.
Probably need to. The photographs, and for record purposes, photographs that the council referred to, pictures of Mr. Allen, which is tattoos that the court did not allow are to the record as court exhibit 3. For health purposes, thank you. All right. You can put them to the group.
And that motion I filed, I think the order I submitted would allow for further dailies only on the basis of
so we want the light close. Okay. Project. Not working? Oh, God. The white noise either?
No, so good, when the guy comes in, he can fix this again. There.
It's one of those trials so far, Judge.
Yeah, I'll have their moments. Spear, you weren't playing with this, were you?
Not that one, Judge.
Making sure.
Isn't because they don't use the white noise in the juvenile courtroom as much? I don't know. Because there's really no juries.
I don't know, but the system seems to freeze up. I don't usually add this as well. They're all ready? Okay. Mr. Allen, it appears that the microphone is not working well, so project.
Jurors are ready to go.
All right, bring them up.
Jurors are entering.
Parties may be seated, call on the order. Parties present. Not even morning. Good afternoon, welcome back. I trust you are all able to avoid any inadvertent exposure to media. Thank you. Appreciate that. Apologize about the late start. It's not the fault of any parties. We're all here, we're all on time. We're working through some other issues that need to be addressed. So again, I appreciate your patience and understanding. I mean, I guess I already used the central time zone thing. I guess I could try like Pacific time for the Super Bowl. I won't do that. We were just busy. But I appreciate your patience and understanding as always. Very patient. Appreciate that. When last we met, Mr. Allen was still on the stand. Council working Mr. Allen, you are the same Robert Allen that was here, on Friday.
Yes.
I remind you, sir, you are still under oath. Counsel. You may
Thank you, Your Honor.
proceed.
Cross-examination, Mr. Good afternoon, Mr. Allen. Mr. Allen, let me start off by going over a few things that came out during the cross-examination by Mr. Padilla, okay? And then we'll go back to the beginning. I don't have a whole lot for you, so I appreciate you bearing with us. In fact, you've been on the stand so long already. I'm gonna try not to take too much of your time. Isn't it true that you testified that you know for sure Trayvon Newsom's gun did not come from your father in this case, correct?
Yes.
Okay, and there is no gun from Trayvon Newsom evidence in this case, correct?
Yes.
But there are other guns that came from your father.
Some of them, yes.
Judge, I'm sorry, I can't hear
Yeah, you need to speak up again and remember the jury. I apologize. The thing's not working again, so hopefully they'll get that fixed at some point. I need you to project as much as you can. Thank you.
And Mr. Allen, when this thing happened, you wanted to flee to escape justice, correct?
Yes.
You also indicated that you were calling the female that was renting the cars on a regular basis because you were renting cars to rob people on a regular basis, correct?
Yes.
And I think you also explained the fact that you didn't have your 4 phones with you on the day of this robbery because you had been doing fraud, and that's why you needed all those phones, correct?
Yes.
And you kind of indicated you had graduated to armed robbery from all the fraud, so you didn't need the phones that day, correct?
Yes.
And you admitted the 12 felony convictions that you have, correct?
Yes.
And you can't recall how you got rid of the phone that you did have with you that day, correct?
Yes.
But you did admit that you got rid of it because you thought there was evidence on there that could make you look guilty in this particular crime, the one you wanted to avoid justice for when you fled, correct?
Yes.
All right. Now, when you went into Riva that day, you testified that you guys went in there to buy a mask, correct?
Yes.
Okay. And that there's some testimony about whether this is actually X, the rapper that was in Riva shortly after you guys went in, correct?
Yes.
Now, you saw the necklace that Triple X had on that day, correct, at Riva?
I don't remember.
You don't remember seeing it at all?
I don't remember seeing it.
Okay. Have you ever answered that question differently?
I don't know.
Okay. Would it refresh your recollection for me to refer you to the page and the statement which you made about that necklace?
Yes.
Judge, I'm going to refer the police interview of Mr. Allen by Detective Curcio on October 23rd of 2018, page 25.
What page, Mr. Perez?
25? And if I might,
You ready?
Mr. Allen, same process you learned the other day. Just read this to yourself and see if this refreshes your recollection. Okay, this does refresh your recollection, correct?
Yes.
And back in 2018, you told Detective Curcio you would only see his necklace as opposed to the bag that he was carrying that was eventually taken, correct?
Yes.
And you remember how the necklace looked now, don't you?
Really?
Okay, well, was it a skinny little necklace like we would wear every day, or was it something large and extremely valuable?
I mean, based on what Deidre told me, yes.
Okay. But you did see it. You admitted that you saw it in 2018, correct?
I don't know if I really see it or not.
This could have been a lie in 2018?
Yes.
Okay. So when you told Detective Curcio you had seen it and it was kind of thick, that was a lie?
I was basically just telling him what Deidre told me.
Okay, but that's not what you were asked, correct? You were asked what you saw, not what you saw.
I told you I lied.
You also testified to something about a crab lock being on that necklace, correct?
Yes.
Were you familiar with what a crab lock was for a necklace?
Yes.
Did you see that crab lock on the necklace?
No.
Did anyone tell you they saw a crab lock on that necklace?
Yes.
Who was that?
Deidre Winter
Okay, now where would a crab lock on the necklace be?
is how the necklace is on your neck.
Pretty likely in the back though, correct?
It could be, or it could be here. I mean, wherever.
So you didn't see a necklace on X that day at all?
No.
Do you have any idea how someone else might have if you didn't?
Objection, speculation.
It's the same.
So when this happened, you saw the video, jury's got a chance to look at it. You're in that car that pulls up in front, correct? That blocks him from leaving the Riva parking lot. At that time.
Dodge Journey?
Yeah.
Yes.
You're in that car.
Yes.
So how far are you from what's happening at that car? I mean,
They're actually standing in front of the window, so I can't see.
okay, but how close are you actually?
I don't know.
Looks like about the same distance I'm standing from you right now. Would that be fair?
Could be.
Because the car pulled right in front of the other car and blocked it off. You're sitting in there and car didn't back up. X's car didn't back up, right?
Yeah, but I'm on the passenger. I'm on the driver back seat.
Right, but you're very close, correct?
I guess. Yeah.
Okay. And what you say is that Trayvon Newsom was reaching in the car trying to grab the necklace off the legs, correct?
Yes.
Okay, and you saw that, you were close enough to see that, right?
And I seen him going like this, so I assume
Grabbing at the necklace, right?
he had it.
Okay. I mean, I think later on you even talked about, well, there was some talk about don't try to grab it because it's got the crab lock on it, it won't come off easy or anything, right?
Yes.
And in fact, you say, well, Trey tried to grab it anyway, even though he was told specifically not to take the necklace.
Yes.
Are you aware, at any time, did you review the discovery in the case that the state has with your attorney?
Not with my turn.
No, did you review it on your own?
Yeah.
Okay. So you know there was no DNA or fingerprints on that necklace belonging to Trayvon Newsom, correct?
I mean, I didn't get the whole discovery.
I'm sorry?
I didn't get the whole discovery.
Oh, you didn't. So if that was in there, you didn't see it? Okay. Now, when you gave your statement to Detective Curcio, your hope was that by cooperating with law enforcement, you get some kind of deal, correct?
Yes.
And is it fair to say the way you were answering questions wasn't satisfying Detective Curcio or Detective Bonds, who I think was there as well, correct?
Objection, speculation, the effect on the listener, and hearsay.
rephrase.
Did Detective Curcio explain to you that if you get your deal and it works out, you're gonna have to be 100% correct in everything you say?
Objection, hearsay.
Not all.
Overruled.
Thank you. Remember I'm telling you? Might I approach with page 58 of the same statement?
Judge, are you not saying keep his voice up, it's going back down to low?
I'm going to ask you if you remember Detective Curcio telling you what I've highlighted here in this portion in the middle of page 58. Okay, so do you remember him saying that to you now?
I still don't remember, but I see it, so.
Okay.
Yeah.
So you have no doubt that this is correct, right? This is correct. And he told you everything you're saying has to be 100%. Even the little details we're asking you about. Remember that?
Yes.
Because you kept saying, I don't remember, I don't remember, right? To a lot of things.
Yes.
Now, is it fair to say some of those things you didn't remember, but some of those things you did, you just didn't want to implicate yourself any worse than it already was? Correct?
Yes.
Okay. But do you remember when he said you have to kind of remember everything these guys were saying? Right? Part of what I just read.
Yeah.
Okay. So you saw when Detective Curcio said you got to kind of remember everything they were saying. Right?
Yes.
Put pressure on you to remember everything, right?
Yes.
Objection asked and answered.
You didn't remember everything. Correct?
Yes.
But the pressure was on you to come up with something, they said, right?
No.
Objection argumentative.
Can I answer the question? Go ahead.
Didn't you feel like the pressure was on you when they're telling you to remember things you don't remember?
I mean, I just think he knew I was lying.
Okay, fair enough, and you weren't gonna get a deal with the lies at that point, right? Because you weren't giving them enough information. Fair enough?
I don't understand.
Okay, well, when a detective tells you during an interview, when you're trying to get a deal from him, that you're not doing very well, because you gotta remember everything 100%, and you gotta remember everything they were saying, but you don't remember everything they were saying. You gotta try to give them something, right? So, fair enough.
Yes.
So some of the lies you made up were based on the pressure that was being put on you at that time.
Objection argumentative.
Sustained.
Did you feel like they were trying to push you to say things that you didn't remember?
No.
They were making different statements? My approach. Page 61, I think you already admitted this.
Yes, I
So I'm just going to show you 61 and see if this is the same answer you did the other day. Okay. So you even told Detective Curcio, I think it's like you're trying to push me to remember, say something I don't know. Right?
Yes.
Sounds like you were getting put under some pressure, and it sounds like you weren't afraid to tell him, hey, you're pushing me to say things and make things up. Right?
No, I wouldn't say it was pressure. I was just trying to avoid not putting myself on the line at the time.
Okay. Now, after this happened, you've testified that everybody is on their phones to try to find out, was this man actually shot? Did this man die? What's on the news? All of that, right?
I don't remember saying that.
I might approach page 42, Your Honor. This is page 42, this is the portion of the
ask Mr. Ramirez to give the line number that he's referencing, please?
Detective Curcio's question on 5 starts at. Recall? Okay. So Detective Curcio says, well, I mean, later on, everybody was on their phones to check the news, like to see what happened, right?
Yes.
And that's true, right? You guys were all on your phones to check what happened, right?
Yes.
Okay. Trayvon too?
I don't think so.
Because you said his phone was working that day, right?
Yes.
Now, later on in that same statement that you gave back on October 23rd, 2018, Investigator Bronson, former Detective Bronson, who was then with the State Attorney's Office, talked to you a little bit too about what you were telling him, right?
Yes.
Okay. And it was clear in your mind, you were there trying to get a deal, right?
Yes.
That's why you were there. And it also appears it was clear that Detective Curcio and Detective Bronson knew you were there trying to get a deal in your case, correct?
Yes.
Now, this may seem like common sense, but the more help you can give the state to prosecute the individuals they think may have been involved, you believe the better your deal might be, correct?
Yes.
And you remember Detective Bronson telling you about how important it's going to be for all the little things that people said, all the little things that people did, to be things you can tell them about, right? They want to know every detail you possibly remember, correct?
Yes.
And you know what the word fruition means?
No.
Detective Bronson used that word. You didn't know what he meant at the time?
No.
Do you know what that means now?
No.
But you remember him talking about your deal, right? Detective Bronson?
What?
No? My approach with page 77, refreshes recollection. Just highlight the portion here. That's that word. Remember that? That refreshes your recollection, doesn't it?
Yes.
So that word fruition, he followed it up talking about you get a deal. But if you blurt something that was said by one of them and you haven't told us, well, wait a minute, you didn't tell them that, he says to you, correct?
Yes.
So again, Detective Curcio and Investigator Bronson are telling you, you gotta remember everything, and you gotta get it right. Right?
Yes.
For the deal to come to fruition, for you to actually get a chance to testify here, as you have finally after many years of attempts, correct?
Yes.
You remember what Detective Bronson said would happen if you didn't get all those details correct and went to trial anyway?
No.
I approach with page 78. And I'm referring to the part where if you suddenly remember something during trial, I'm sorry, Judge, right here. Remember when you said that? You did?
Yes.
Okay. Did that? intimidate you a little bit, scare you a little bit when you said that to you?
No,
So when you said if you suddenly remember something during trial, they're gonna shove it up ours and your rear end, that didn't intimidate you?
no.
That's what you've done here. You've suddenly changed your testimony again and again and again. Isn't that true?
Yes.
Remember towards the end of your statement on October 23rd, 2018, you had a visitation that day at the jail, right? May I approach with page 84?
What page?
84. I'll ask you to read the whole page here. I've only highlighted the question I'm going to focus on, but you'll get the context by reading the whole page.
Judge, if we may go sidebar.
Thank you.
It's with respect to the section that Mr. Perez is.
Well, we can come over here,
Okay.
just not gonna have the noise. But let them look at it first and then we'll sidebar before the question gets asked.
Tell me what the objection is. Just let it go, or you want to?
No.
Okay.
We're sidebar.
Come on. Come on. Mr. Allen, again, you were placed under oath about your knowledge or involvement in this particular matter. When you spoke to Ms. Machida on July 28th, 2022, you remember that day, don't you?
Yes,
And you remember her coming to you, and or maybe you were going to her and gave a statement to her, correct?
yes,
And you remember Mrs. Shield asking you if you lied in your former statement, the one we just talked about, that was taken October 23rd, correct?
yes,
On that day and time, you still maintain that you didn't know there was going to be a robbery taking place, correct?
on July 28th,
I'm sorry?
on July 28th, October.
Right, you're still telling Mrs. Shield that you didn't know there was going to be a robbery.
That's probably,
And she went on to ask you, did you know that they had guns? No, I didn't. I didn't really know what was in the bag in the backseat. And here you told everybody, yeah, there were guns in the backseat. We do again robberies regularly, right?
yeah,
And what you told Mrs. Shield was like the purpose here was to get the bag, right? That X had, right?
yes,
Because somebody made an assumption that there was a lot of money in the bag, right?
yes,
You said here in court testified that the assumption was there was $100,000 in the bag, right?
yes.
Where would that have come from back then? How would someone assume there was over $100,000 unless somebody knew more than what we're hearing here about that man going to the bank and taking money out, going to Riva?
Well, I don't know if you have Instagram, but there's a lot of that goes on Instagram when people goes into stores, they have a designer bag, and a lot of times there'd be 200,000, 400,000. I mean, they have all type of money.
So that's where that number came from, 100,000. Because you saw stuff on Instagram where people bring hundreds of thousands of dollars.
That's right.
in designer bags.
Yes. Celebrities, I should say.
And you're also still on July 28, 22, saying that the mask that was purchased was going to be just for dirt bike riding, not admitting that it was to be used in a robbery, correct?
Can I see it?
Don't remember saying that. Now I approach with page 18 of the 7/28/22 statement. Okay, correct? So I'm still saying, I don't know anything about robberies. I didn't know there were any guns. I thought they would use the mask for the dirt bikes, right?
Yes.
Now, here you testified at trial that you were certain of how the money from this robbery was broken up between, you said, 4 people, right?
Yes.
You got the numbers wrong back in 7/28/22. You had it different, right?
Yes.
How did that change? What made you suddenly know the numbers correctly when just in July of last year, you testified under oath to different numbers?
I really just said numbers.
I'm sorry?
At the time, I just said numbers.
You just threw out numbers.
Yeah.
So are
You're just,
throwing out numbers here too?
no,
Well, why would you lie about the numbers? How would that make you look less guilty, lying about the numbers that other people have?
um,
And here, you testified, I think, on cross-examination that, you know that cars were rented often from the young lady who rented the car here for the purpose of robberies, right? That's what your testimony is here, correct? But back on 7/28 of 22, you said you had no idea, right?
I think I did, yes.
And you also said you had never rented any cars from that lady before, right?
Probably did, yes.
Okay. Who are you trying to protect there?
Myself,
Not the lady that rented the cars,
no.
just yourself?
She didn't know I was renting cars.
She didn't know why you guys were renting the cars?
No.
Or when you were renting the cars? Now, here you testified pretty specifically about all the firearms that you say were involved in this particular crime, right?
Yes,
You didn't know back in 7/28/22 what kind of firearm you were gonna say Trayvon had, right?
which I didn't know.
You didn't know. Isn't that true?
I don't get what you're saying.
Do you remember being asked, what kind of gun did Trayvon have?
All of that.
And your answer was, I think, it was 357, one of those.
Yes,
But how can you go from then, not sure, to definitely here, I know it was a 38. Somebody tell you, we think it was a 38, so that's what you have to say.
no.
So how did you get that wrong? Why would you lie about that back then if you in fact knew exactly what gun you were getting?
I said 38 or 357
Well, you,
because I wasn't too sure, but
you didn't say that here and testified, you were sure, right?
yes,
Now, you do know something about guns, right?
yes,
You know 338 and 357 don't look much alike at all.
38 with a long barrel, yes, they kind of
You think it looks like a 357?
both have the same, they both have long barrels.
Probably the only thing in common, you're right about that. Now, there are some photographs that you were shown here of people posing with money, right?
Yes,
Okay, and you admitted that you were in those pictures, some of those pictures posing with money, right?
yes,
And you have done that in the past on other occasions, several times, if not more, correct?
yes,
In fact, you and all your friends got a bunch of money, posed with pictures of it for Instagram or Facebook or this or that, right? That's commonly done, right?
yes,
Okay. In fact, you were shown some photographs of you posing with some money during that statement of 7/28/22, correct?
yes,
Okay? And you said that money had nothing to do with this crime, that was from 2 months before. I'm saying that.
yes.
Okay. I think you also said that, the money you had in there might have been from a girlfriend that gave you the money, or some other friend that gave you the money to hold, right?
Different pictures, yes.
All right, so you've been arrested Years have gone by, you're still trying to get a deal. You finally have an opportunity to come in here and testify the way you are to this jury. Get your deal. At that point, you have to give a deposition to the defense counsel in the case because you're going to be a state witness, right?
Yes,
Okay, you gave that deposition on December 8th of 2022, right?
yes.
Okay. Now, on December 8th of 2022, just some months back here, you were asked about other statements that you had made previously under oath, where you didn't say the same things you were saying, correct?
Yes,
Okay. And you still didn't want to admit you had lied in those earlier statements, right?
yes,
However, when you were asked, was everything you said in the 7/28/18 statement 100% the truth, you testified yes under oath on December 8th, 2022. Remember that? I understand your memory may not be that good, but something like that. I'm going to go to page 10 if I might, of the deposition under oath, Robert Allen, December 8th, 2022. Any question by Mr. Kim?
You said page 8?
I said page 8.
Line, please, when you get it.
Yeah, you know, I'm sorry, it goes on from page 8 all the way to page 10, and the point I'm making is on page 10. So if you want to glance at page 8, here they're asking you questions about that statement, prior statements. And the important part that I'm saying, you're asking me about is on page 10. And this is where you say, it's not possible. Okay? Remember, that refreshed your recollection, right?
yes,
So you maintain it to 3 pages here. No, I didn't lie, it's not possible I lied, right?
yes.
And let's just briefly go back to that necklace. Because you were asked about that necklace at the deposition. You remember that, don't you?
Yes,
Okay. Do you remember what you said about my client being told something about that necklace?
yes.
What did you say?
Deidre Williams told him not to grab the necklace because it had a crab lock on it.
Not to try to grab the necklace because it had a crab lock.
Yes,
So I guess somebody knew there was a crab lock on that necklace, right?
it was Deidre did.
You didn't see that. Did
No.
you? You didn't even see the necklace, you're telling us.
No.
Okay. So a crab lock makes the necklace harder to steal, right?
Yes,
Doesn't make it impossible to steal, does it?
yes.
You think it does?
Oh, no,
No, I mean, you can
It
still
takes
rip it
longer.
off somebody's neck if you grab it right and pull hard enough, right?
yeah, but it'll take longer. It'll take longer,
I'm sorry, I didn't hear you.
it'll take longer.
It'd take long.
Yes, the robbery will,
You probably gotta grab it harder, right?
I mean,
You gotta get your finger on it, right, somehow.
I don't know, I would tell him to take it off.
So, but your testimony is that before you say that 2 of these men got out of the car to commit this robbery, that the 3rd man who's on trial, he said, don't try to take that necklace because it has a crab lock on it. Even though we have no idea how that person would have known that or why they would say that, right?
Yes,
But you say you saw the person on that video reaching in, grabbing at the necklace, trying to pull it off, right?
yes,
And that's pretty clear on that video, correct?
yes.
In fact, you said that, you said Trayvon was doing this, but obviously on the video, somebody was trying to pull that necklace off, struggling.
Yeah.
Now, you also changed your testimony when that was over, finding all that money, right?
Yes.
And I presume that you lied about that to, again, to minimize your involvement.
Yes.
How would that minimize your involvement to lie about when the bank was open?
I'm trying to make it seem as I didn't have no knowledge of nothing. I didn't know nothing. I didn't want to know nothing.
Didn't know anything about what was in the bag.
Yes.
In fact, at one point you said there was discussion about, don't open the bag now, don't open the bag now. And then later you said, no, the bag was open right in the car.
Yeah.
It kind of makes more sense if somebody steals a bag and they're getting away, they're gonna look in the bag, right?
Yeah.
Now, after this happened, you decide you're gonna try to escape justice, you're gonna flee, and you go to Fort Pierce, correct?
Yes.
Do you remember where you stayed in Fort Pierce?
No.
Do you remember how you got to Fort Pierce?
Yes.
How'd you get there?
My dad's like smokers.
I'm sorry?
One of my dad's like smokers, like addicts, whatever. I don't know what you call it.
Dad's smokers or addicts? I'm not sure I understand what that means. I'm pretty sure the jury is.
My dad is a drug dealer, or was a drug dealer, and I'm assuming he paid him or whatever to take us to Fort Pierce.
So your dad paid a drug addict to take you to Fort Pierce to escape justice in this case?
I don't know if he paid him or not, but I'm assuming he did.
Okay. And was this a car, a truck, or a van? Don't you remember what kind of car you were driving in from Fort Lauderdale?
I know it was a car, but I don't know what kind of car. I don't remember.
So it was a car, or was it a truck or a van?
A car.
Okay, do you remember being asked that question at that deposition on December 8th of 2022? Turn to page 72 of my approach. Right? So when you were asked, was it a car, a truck, a van? I don't remember was your answer, right?
Yeah.
And now today you tell us, okay, it was a car. Right? That answer, yes.
Yes.
Okay. And towards the end of that deposition, you were asked, whether you had lied previously, because obviously some of the things you were saying here weren't what you had said before, right?
Yes.
And when you were asked if you had lied before in the case, you remember saying no. I didn't.
Yes.
Another lie, right?
Yes.
Judge, can we go sidebar first?
So, in your mind, Mr. Brown, you're well aware that the better you testify here, the more likely you are to get the deal that you want. That's correct.
Yes,
So you know that if your testimony convicts these three men, you're probably gonna get a better deal than if it doesn't, correct?
yes,
Now, you've already testified that in terms of what you hope to get, what you might expect to get, that you were advised by your attorney that you might get 5 or 6 years here. Right?
yes,
How long have you served already, sir?
close to 5 years.
So you might walk out of here a free man if you get these 3 men convicted with this kind of testimony?
Judge,
I don't have anything further. Thank you very much, sir.
Just like that, Mike. All right, ladies and gentlemen, so in talking with counsel, because we were dealing with some matters this morning, you were waiting around, I want to kind of try and avoid some of that. There's some other matters that we need to discuss and things that we need to go over. And I've been trying to gauge time with council on how long these discussions will go on, and they could be for a couple of hours. So you got lunch, and then a couple of hours of us talking with you sitting, and at this point, I'm not gonna waste the rest of your day and have you just be here for another 30 minutes in the late afternoon. You've been patient enough. So I'm gonna recess you guys for the rest of the day so we can work with what we need to, and then when we come in tomorrow, all that's been fleshed out. I think at least that's more fair to you than having you hang around for slow lunch and 2.5 hours of sitting in the back to get another 30 minutes of testimony today. Also, I do want you to understand that, as I told you before, trials like this, we have things that come up. This is kind of normal, everyday things that happen in trials. I'm quite used to it. And so what I don't want you to think is, oh man, this puts us a half a day behind schedule. The schedule that we gave you at the beginning, about how long we thought this case would take, anticipated these types of delays. So this isn't putting us off course. This is just, part of what we figured would be going on. I want you to understand that as well. But I just think in fairness to have you sit around all day for another 30 minutes, you're better off going about your personal affairs and coming back tomorrow, and then we'll have a longer stretch. So if that's acceptable to you, I will excuse you for the rest of the day. As with each time we break, I'll remind you not more than you have to do meetings and basically hear all the evidence, arguments, counsel, instructions, and law by me. Until that time, do not discuss the case even among yourselves. During the course of the trial, we take recesses. You're permitted to separate, go about your personal affairs. During these recesses, you shall not discuss the case with anyone or permit anyone to say to you in presence. Anyone does, on the jury has to stop, leave them, or matter deputy. If you see any parties, witnesses, defendants, anyone else associated with the case in the hallway, anywhere else, they ignore you. They are not being moved, following the court's orders. I'm hopeful that we will get underway at 10:30 sharp. So I'll see you tomorrow morning. Have a great rest of your afternoon. Enjoy.
complaint charging you under 265 Section 1, Count 1 murder, juvenile 1. Count 2, 265 Section 1 murder, juvenile 2. Count 3, 265 15D Big A, strangulation or suffocation, juvenile 1. Count 4, 265 15D Big A, strangulation, suffocation, juvenile 2. Count 5, 265 15D Big A, strangulation or suffocation, juvenile 3. Count 6, 265 15A Big A, assault and battery, dangerous weapon, two-way exercise rope, juvenile 1. Count 7, assault and battery, 265 15A with a dangerous weapon, two-wit exercise rope, juvenile 2. And count 8, 265 15A, assault and battery, dangerous weapon, exercise rope, two-wit, juvenile 3. Man, a plea of not guilty will be entered. Please be advised while this case is pending, any violation of state, federal, or local law may result in bail being revoked and be held without bail.
Commonwealth, I'll hear from you first.
Thank you, Your Honor. The Commonwealth is requesting that the defendant be held without bail based on the facts of the case, the strength of the Commonwealth's case, and the potential penalty. On Friday, January 27th, 2023, using an erasable whiteboard because she was still temporarily intubated, one of the first questions that Lindsay Clancy asked was, "Do I need an attorney?" She knew that she had murdered her children, and she had the clarity, focus, and mental acumen to focus on protecting her own rights and interests. The following is a summary of the events that led to the murders of Cora Clancy, Dawson Clancy, and Callan Clancy. On the morning of Tuesday, January 24th, 2023, the defendant took her 5-year-old daughter, Cora, to the pediatrician's for an appointment. She interacted with a receptionist, nursing staff, and a doctor. There were apparently no issues with the defendant's demeanor or behavior as she completed the appointment and was allowed to leave with Cora without any issues or concerns. When she returned home, she went outside with Cora and her 3-year-old son, Dawson, to play in the snow. They built a snowman. The defendant sent photos to her mother and to the defendant, to her husband. She texted with them. Nothing in the text was out of the ordinary or any sign of any distress or trouble. Back inside later that day at 4:02 p.m., the defendant searched on her phone Kids Miralax. She then searched at Takeout 3V via her cell phone at 4:13 p.m. Immediately after doing that, she used Apple Maps on her phone to determine how long it would take someone to drive from her home in Duxbury to 3V restaurant in Plymouth. So she would know how long someone would be gone if they ran that errand. She next went on the CVS website at 4:47 p.m. and then called CVS on Summer Street in Kingston. She spoke to the manager of CVS and asked if they had the Kids Miralax. The manager told her no, but they had other similar medications. According to the manager of CVS, her voice did not sound slurred or impaired in any way. She had no trouble understanding the defendant, and it was a perfectly normal conversation. At 4:53 p.m., the defendant texted her husband, who was working in his home office in their basement. She texted, "Any chance you want to do takeout from 3V? I didn't cook anything. It's been a long day." This was an unusual request, as when the family ordered takeout, they usually go somewhere closer to home, but it was a place that they had been in the past. Patrick Clancy texted back yes, and then the defendant asked him to check the menu. At 5:06 p.m., the husband texted the defendant asking what she was going to get. She responded, "A Mediterranean power bowl." She spelled it correctly, and it was something that was on the menu. He then told her that he wanted the scallop and pork belly risotto. At 5:10 p.m., the defendant called 3V Restaurant to place the order. She got the order correct. She gave the correct name for pickup, Patrick. The hostess who took the call said there was nothing out of the ordinary about this call. She was able to understand the defendant, that her voice was not slurred or impaired in any way. At 5:15 p.m., Patrick Clancy headed out the door to run these errands at the defendant's request. As he left, she texted him Pedialyte liquid stool softener. Surveillance footage shows Mr. Clancy at CVS on Summer Street in Kingston at 5:32 p.m. He goes to the medication aisle, the children's medication aisle. Phone records show that he called the defendant at 5:33 p.m. and she did not answer the phone. She then calls him back at 5:34 p.m. and the call lasted 14 seconds. He's there at the store unsure of which medication to get, and she tells him exactly what she wants. He had no issues communicating with her. It was a completely normal call, although he did mention that she seemed like she was in the middle of something.
Have an H&R Block Tax Pro do your taxes online, and tax season feels just as good as all those other seasons. Like fishing season.
You caught a big one, buddy.
Football season.
Tax season is back.
He is on surveillance footage during this time, exiting that aisle and appeared to be using his phone. He then heads to the register, makes his purchase, and leaves the store at 5:37 p.m. He's next seen on footage at 3V restaurant at 5:54 p.m. He picks up the food and he's out of there within a minute. When he arrives home, the first thing he noticed was the silence. He did not see or hear the defendant or the children. He actually called her cell phone at 6:09 p.m. looking for them, and she did not answer. He went to their bedroom on the second floor and the door was locked. He was able to open it, and when he looked inside, he saw blood on the floor in front of a full-length mirror and the window open. He immediately runs downstairs and into the backyard, where he finds the defendant laying on the ground. She appeared to have cuts on her wrists and neck, but he stated to 911 that those wounds were no longer bleeding. She was conscious. He called 911. During this time, he asked the defendant, "What did you do?" She responded to him, "I tried to kill myself and jumped out the window." During the 911 call, Patrick can be heard asking the defendant, "Where are the kids?" He later told police that she replied, "In the basement." So immediately after this happened, she knew what she had done and she knew where the kids were. When EMS arrived, he asked them to stay with her so he could go find his kids. The 911 call kept going. Patrick can be heard on the 911 call entering the home and heading to the basement. At one point, he calls out, "Guys." He can then be heard screaming in agony and shock as he found his children. His screams seem to get louder and more agonized as the time passes. Cora and Callan were on the floor in the den area of the finished basement, which is to the left when you walk down the stairs, while Dawson was alone on the floor in his father's home office, which is to the right when you go down the stairs. Each child still had the exercise band that was used to strangle them tied around their necks when their father found them. Dawson and Callan were face down on the floor. Cora was on her side with her torso turned towards the floor. He removed the bands and begged them to breathe. He continued to scream uncontrollably and screamed for officers to come to the basement. The dispatchers are hearing this and they send help down to the basement. And when they encounter Patrick, he yells out, "She killed the kids." The police rushed the children to ambulances that brought them to the hospital. And unfortunately, Cora and Dawson were declared dead at the hospital. Callan was med-flighted to Boston Children's Hospital. Medical staff was able to restart his pulse, but not his brain activity. He was placed on life support for several days before passing away. The defendant was transported to South Shore Hospital and then to a Boston area hospital where she remains. She sustained several broken bones in her back and her rib cage. The police were able to find several notebooks in the defendant's home pursuant to a search warrant, and also notes on her phone that were similar to journal entries. In the months, weeks, and days preceding January 24th, 2023, the defendant meticulously detailed her daily activities, her children's lives, her mental state, and her medication use. Her writing was clear, precise, and articulate. She never indicated that she was hallucinating, delusional, or had disordered thoughts or speech. In all of her writing, she appears to know who she is, where she is, the date, and with whom she's interacted. She wrote a note on her phone the day before killing the children, stating that she had, quote, "a touch of postpartum anxiety," end quote, around returning to work. She wrote that her psychiatrist had prescribed medication to help her. The defendant was initially diagnosed, according to her husband, with generalized anxiety disorder. She was then evaluated at the Women and Infant Center for Women's Behavioral Health in Providence, Rhode Island on December 20th, 2022. There, after an evaluation, she was told in the presence of her husband that by psychiatrists that she did not have postpartum depression and that she had no symptoms of postpartum depression. She wrote in her journal that at times she had suicidal ideation in December of 2022, and she also told her husband that she had suicidal thoughts and on one occasion had thoughts of harming her children. But she did not write or voice those thoughts after a stay at McLean Hospital. When she had those thoughts, she consulted with a psychiatrist and with her husband, and then she committed herself to McLean Hospital on January 1st, 2023. She was discharged by the hospital on January 5th, 2023, and the hospital did not file any paperwork at that time attempting to have her committed as a danger to herself or others. She also kept meticulous and detailed daily medication logs in a diary that she wrote. She detailed that she had difficulties with each of the medications that were prescribed to her. And when she had issues with those medications, she detailed how her doctor had her stop that medication or wean off of it and then try something else. They were trying different medications to see what would work for her, what would benefit her. According to her husband, she was never on more than 4 to 5 medications at one time. And at the time of the murder, she was taking only 3 medications. And he said to the police that she always took the medications as prescribed.
Get matched with an expert who understands your situation. They'll do it all for you and ensure you get every dollar you deserve. Get TurboTax Live Full.
After her stay at McLean, the defendant appeared to be getting better, according to her husband. She slept well, interacted with friends and family. She went out with her kids and husband to places like the Kingsbury Club in Duxbury, the Charlie Horse Restaurant, the Museum of Science in Boston, the Cape Codder down the Cape, interacting with her family and the public without any apparent difficulties. She even stayed alone with the children on several occasions without any issues in January of 2023. Her husband asked her in mid-January, "Are you still having suicidal thoughts?" And she said no. The defendant's parents visited the family the weekend of January 21st, 2023. They interacted with the defendant in person. The defendant was able to run errands while her mom watched the children. She texted back and forth with her mother, and there was nothing out of the ordinary about these text messages. In fact, the defendant texted her mother on January 22nd, 2023 to ask how her ride home went. During this conversation, the defendant's mother wrote, quote, "Enjoyed seeing everyone this weekend. Nice to see you doing better," end quote. On the night of the killings, Patrick Clancy was interviewed by the police at Beth Israel Deaconess Plymouth Hospital. He told the police that the defendant was having one of her best days. She was smiling and happy, and there was no indication that she was going to harm the kids. No one at all described her as acting like a zombie in the days leading up to the murder or on the day of the murders themselves. On February 5th, 2023, this past Sunday at 1:35 p.m., while sitting with Dr. Paul Zeisel, the psychologist hired by defense counsel to evaluate her mental state, the defendant used Dr. Zeisel's cell phone to call her husband. She left a voicemail stating that she loved him. Yesterday, on February 6, 2023, at 10:09 a.m., she again used Dr. Zeisel's cell phone to call her husband. This time he answered, and during this call, the defendant stated that after he left the house that night, she killed the kids because she heard a voice and had, quote, "a moment of psychosis," end quote. He asked her what voices she heard, and she said she heard a man's voice telling her to kill the kids and kill herself because it was her last chance. Patrick Clancy told the police the defendant had never heard voices before. He also told the police the defendant had never used the word psychosis to him before. The first time she used that word psychosis was when she was with the doctor hired by defense counsel and using his cell phone. The defendant actually wrote a note on her phone on October 25th, approximately 3 months before this happened, October 25th, 2022. She wrote, quote, "I think I sort of resent my other children because they prevent me from treating Cal like my first baby. And I know that's not fair to them. I know that. I was feeling so depressed last evening when Cora and Dawson came home from school. I know it runs off on them, so we had a pretty rough evening. I want to feel love and connection with all of my kids." She then wrote that she wants to have more kids eventually. The children were killed by ligature strangulation. Ligature strangulation causes the victim to become unconscious anywhere from 10 seconds up to a minute. The more the victim struggles, the longer it takes. After the victim is unconscious, the ligature must be held in place with force, squeezing the neck for up to an additional 4 to 5 minutes to cause death. Therefore, she had to strangle each of them to unconsciousness and then make sure the bands were squeezing their little necks for several minutes. She could have changed her mind at any point during that time and removed those bands from their necks, and she did not. The defendant did not take advantage of the situation when her husband left the home that night. She created the situation, and she used Apple Maps to make sure she would have enough time to strangle each child before her husband returned from where she had sent him. The defendant is a danger to herself and others. She planned these murders, gave herself the time and privacy needed to commit the murders, and then she strangled each child in the place where they should have felt the safest, at home with their mom. She did so with deliberate premeditation and extreme atrocity and cruelty. And to supplement what the defense counsel has provided, I have a statement if you're allowed me to file with the court. And thank you, Your Honor.
Thank you very much. Attorney Reddington.
Thank you very much, Your Honor. Your Honor, my request is that the court not enter what is an inhumane order, ordering this woman to be incarcerated. We all know, as people that work in the system, that jails and prisons are woefully deficient in medical care of the most basic type. We all know that this is an individual, as Rhonda knows from Dr. Ricard's letter, who is in dire medical condition. We all know that this woman is, as counsel concedes apparently, a danger to herself. I question whether she would ever make it to a trial. She's suicidal. She's extremely emotional. However, she's unable and has been unable to express any happiness or sadness or cry. And in fact, sometime about a month or two ago, she made the comment, "I just wish that I could feel something." Now, our society fails miserably in treating women with postpartum depression or even postpartum psychosis. It's medicate, medicate, medicate. Throw the pills at you and then see how it works. If it doesn't work, increase the dose or decrease the dose. Then end up trying another combination of medications. We're talking a relatively short period of time from when that baby was born in October up until January, when this incident occurred, Your Honor, that she was on such significant dosage of medication. Your Honor knows that Cora was born in 2017. It was a very uneventful, normal pregnancy and delivery.
Find your relief from back pain, neck pain, migraines, and more at The Joint Chiropractic. Wilderness Resort. Explore what's new.
No issues afterwards as far as anxiety. Dawson was born in 2018. Again, it was a normal birth. She had no significant issues as far as anxiety. She did have to have stitches and she was sore, and that was about it. Then, of course, Callan was born. When Callan was born, she ended up becoming depressed, suffered from significant anxiety, as a result of which she consulted with a number of doctors. A number of doctors indicated that she would be able to sleep, she would be able to feel, she would be able to emote once these medications kicked in. And again, as I say, our medical in our society completely abandons women with this condition. It's easy to say, come on, you have a healthy baby. You have a wonderful husband. You're able to take care of your kids in your home. You're lucky. Take the pills, you'll be okay. Well, they put her on a number of medications. They put her on Prozac, which Your Honor is well aware, is what's known as SSRI, selective serotonin reuptake inhibitor. Your Honor knows that along with some of these medications, they have the black box warning from the FDA, may cause suicidal ideation, may cause homicidal ideation. She was on Ativan. She was on Benadryl. And then she ended up being told, okay, because she was complaining about the effects of the Prozac, they said, stop the Prozac, we'll find something else. They put her on Remeron. Then they added on Seroquel. And Your Honor, I attached from David Benjamin, the toxicologist, some papers with the submission, and Your Honor can see the side effects that this Seroquel causes. She was having bad thoughts. She was having worsening depression. Her husband suffered through that phase. Her parents were well aware of the fact that she was suffering from this depression and depressive phase. She wasn't sleeping. She ended up, at some point, Your Honor, December 31st, she was on Seroquel. They told her then the Valium would be stopped. She was a shell of herself, no personality, and went to the doctor again. The doctor again prescribes the Seroquel, and then they took her off the Seroquel. And then she went to the doctor, and at that point, they prescribed trazodone, Ativan, amitriptyline, right up to the very end, when she was so bad that she voluntarily turned herself in, if you will, to the McLean Hospital. We know that that's a psychiatric hospital. She was at the McLean Hospital for a period of about 5 days. While at the McLean Hospital, they basically tried to get her off the Seroquel. She wanted to get off the benzodiazepines. She felt that she was being addicted to the benzodiazepines. She then ends up on trazodone, Ativan. Her mood was terrible after she got out of McLean Hospital. She still had the suicidal thoughts. As the government has indicated, she even told her husband that she had suicidal thoughts. You think this is something that she's planning to kill these 3 kids by going and getting a menu, going on to Google Maps or whatever it is, and finding out the distance? When she tells her husband she's having suicidal thoughts, probably a month prior, thoughts of hurting her children, they go to the doctor again, and she's on the medications, on and off, on and off. This is a significant issue between the postpartum depression as well as possibility of postpartum psychosis that is pretty much ignored. But nevertheless, with the overlay of the SSRIs and the history, and Your Honor has some emails and things that people would reach out to me from all over the world, indicating that their daughter had the same problem, that they had the same problem. Your Honor is well aware that many times when people are on Prozac or on SSRIs, workplace violence, homicides, family homicides. This is clearly a tragic, which is a word that's used too much in the criminal justice system, but this really is a tragedy, this case. So we have, obviously, I would suggest, a very good defense for this young woman. She's 32 years of age, Your Honor. She met her husband. He was the love of her life. They got married. Wonderful young couple. And as counsel noted, she always wanted to have kids, always wanted to have babies. She's a nurse. She went to be a midwife because she wanted to help other women that would be in having babies, but didn't want to have all the medications. She was not a big medication person. Your Honor saw, I think there's probably close to 50 letters that have been submitted to you, and I know you read every one of them. The incredible outpouring of support by other nurses that work at Mass General Hospital. The fact that these women have a vigil, that they write the letters to this court imploring you to understand that you sentence, as far as bail issue, the woman before you, who was a beautiful person, who was thoroughly destroyed by these medications. That's for another day, obviously. A bail issue, bail argument. Your Honor is well aware under Commonwealth versus Vasquez at 481 Mass 750, Supreme Judicial Court indicated that this court, or the court, has vested in sound discretion of the bail judge. And the main considerations would be obviously the usual bail considerations: nature and circumstance of the offense, likelihood of success on the defense, roots in the community, and of course, as the in Vasquez case, as well as Commonwealth versus Herring, 489 Mass 569, defendant's risk of flight.
I am the perfect human.
At 2 Men and a Truck, we'll treat you and your belongings.
So now you have a situation, Your Honor, where this woman has incredible support, as you saw, letters from Foxborough that were signed by about 15 women, letters from her family, friends, letters from, people she's known since the 6th grade that have stayed in touch with her. One thing that's a theme that is readily apparent is that Lindsay loved her children. That she would always, one of the letters said, she would always rub her belly, rub her belly. She had pictures of her pregnant, standing next to Patrick, hanging on the wall. I was in the house. The house is absolutely loaded with indicia of love for those kids. Photographs on the wall, little drawings, all sorts of games, toys, playpens, bassinets in the living room, in the dining room, the kitchen loaded with toys. Virtually the entire house, including their master bedroom. Toys, things for the kids. This is not a situation, Your Honor, that was planned by any means. This is a situation that clearly was a product of mental illness. Now, under the Vasquez case, one of the issues, as I said, is whether or not there's a risk of flight. Now, I did submit to Your Honor a letter that was written by her physician, her attending surgeon, Nakul Rekha. This doctor was in surgery until 8:30 at night and actually took the time to write this letter for you to review. And I just want to make note that he makes reference to the fact that she is now in her 12th day of hospitalization following admission on January 25 after a 20-foot fall. She suffered, unlike when the government Friday was saying that she can move her legs and she's getting better, she's okay. No, she's not okay at all. He indicates that she suffered several severe spine fractures, including spinal cord transection. You know what that means. At the level of T5, T6. As you know, she had surgery for this from the orthopedic spine surgical service who performed a decompression infusion. Unfortunately, she is not expected to recover meaningful function at this point below that level of the spinal cord, which makes her a paraplegic, unable to move her legs or feel sensation from below her, he refers to umbilicus or belly button. He says she has no function below this level. Additionally, less active issues include rib fractures in the chest, both sides, cervical spine fractures, necessitate the wearing of a collar around her neck due to the cervical spine fractures. She's paralyzed. The doctor indicates that she needs significant medical treatment. Doctor recommends that she would be discharged to Spalding Rehab. Now, you know that we have Spalding Rehab. You know that we have the Worcester Hospital. This court is vested under Vasquez with your authority to have this woman not held on bail. Perhaps put a GPS on her, I guess, if someone's concerned that she's going to miraculously recover, which isn't going to happen. As your Honor knows, being a paraplegic, paralyzed, she can't move, can't get off the bed, she can't walk, she can't even go to the bathroom. She has to have 24/7 medical care. Her emotional state is so bad that there is a significant fear of suicide. She has to have someone sit in the room 24/7 to watch her. They don't talk to her. They're not, chatting it up. They just sit there and watch out of that concern that she would commit suicide. So you have a paraplegic who can't walk, who is definitely a danger to herself, and the government wants to put her in where? Framingham State Prison? Plymouth House of Correction? There's no way that any humane person would do that, especially within the structure of our criminal justice system, where a person is presumed innocent. And I'm not suggesting with the facts that the government has read, but she has a good defense. She's got a darn good defense to this case, because that's what happened. And I just want to share with you, Your Honor, one of the things that's interesting. When I was in the house, I came across a drawer that had a bunch of pill bottles in it, and I called the DA and I said, I got these pill bottles, and we made arrangements. I'm going to be giving them to them. And it's all the Prozac and the Trazodone and all that stuff. But inside the drawer was this little vase. And I didn't know what it was. It just looked like a little vase to me. And my wife said to me, oh, that looks like a wish vase. I said, what's a wish vase? She said, when people write down little wishes and they put little pieces of paper and they put them inside the vase. And there are literally dozens of these little pieces of paper that talk about Lindsay's wish for happiness and health for her children, that she could get pregnant again, that she would be able to be with her children, little Callan, Dawson, Cora, that they would be happy, healthy, and successful. This is not a woman, Your Honor, that had any reason to harm those innocent children. My request, Your Honor, is that the court would put her on a GPS if you feel that's required, and let the doctors continue to treat her. Let her go to Spalding Rehab. She will sign a waiver that allows probation at any time to speak with her treating physicians or social worker. Find out how she's doing. Does it look as though she's getting close to regaining the ability to walk, which she isn't, but nevertheless, they would be able to do that. And then the government would be notified, and they can come back in here again and try to hold her without bail. And my request would then be to Worcester for the emotional and the mental illness aspect. I don't think that it's fair or just or consistent. Our duties to each other as human beings to put her in jail. I'm asking that she be allowed to continue with her medical treatment.
Commonwealth?
Your Honor, if I may, I did look into medical treatment if she's held. We were under the impression we had received information before that she could move her legs, but then we learned updated medical information that she, for the time being, is paralyzed from the waist down. If she is held, she could go to the Shattuck Hospital. If Shattuck does not have what she needs, she can be sent to another facility, and the corrections officers would go with her there. Shattuck would actually work with her, the doctors at the hospital she's currently at, to determine the best course of treatment. And if whatever she needs, she's going to get. But as defense counsel said, she is a danger to herself and, from the Commonwealth's perspective, others. And just because she is paralyzed does not mean she's not a flight risk. She will be in a wheelchair eventually, and she can be driven somewhere, she can be flown somewhere. It does not mean that she will never be able to leave this area.
Just would like to say that
Sure.
Yeah, sorry.
Go ahead.
Thank you. I have been, unfortunately, in the Shattuck Hospital. To suggest that she can get, quote, what she needs from the Shattuck Hospital is absolutely not true. The care that she's receiving at the hospital she's at now and the care that she would be receiving at the Spalding Rehab are light years ahead of the dismal, dank conditions of the Shattuck Hospital that we put our prisoners in. It's like something out of Iran, and that's not fair or correct.
Thank you both. Both of you, all of you who appear before me that will be litigating this case are all very well respected. And I'm sure at some point in time in Superior Court, this case will be tried in a very professional and very well by both sides. As counsel stated in Commonwealth v. Vasquez, the Supreme Judicial Court addressed the issue of bail in first-degree murder cases, and Justice Lowy issued a detailed decision about the issues in these types of cases. The court found that a defendant charged with first-degree murder has no right to bail, but may be admitted to bail in the discretion of the judge. The court ruled that a judge should consider the nature and circumstances of the offense and weigh the defendant's risk of flight in light of the strength or weaknesses of the Commonwealth's case and the potential penalty of a sentence to life in prison. The court further noted that appropriate considerations for a judge would include the defendant's family ties, financial resources, length of residence in the community, character, mental condition, record of conviction, the appearances at court proceedings, or any previous flight to avoid prosecution or failure to appear at any court proceeding. It is important to note that the purpose of bail is not to impose punishment. The court has conducted a careful review of the details of the case and the defendant's history. The court's reviewed the filings that have been made, as well as letters submitted by counsel for the defendant and the update that was received from her attending trauma surgeon. The factual allegations in this case are both horrific and tragic. The potential penalty faced by the defendant, if convicted, is severe. The defendant has no criminal history. She does not even have a driving record. There is no evidence of any history of any abusive behavior by the defendant. The defendant was raised in New England and has extensive ties to the local area. She has an extremely supportive family. She had worked for several years in a local hospital, and a number of co-workers have written letters in support of the defendant and her character. She's described in these letters as an exemplary worker, colleague, and friend. In the letter submitted by her attending trauma surgeon, she has extensive injuries that will require long-term inpatient rehabilitation. Weighing what the doctor has written and the facts from the defendant's current condition, the court finds that there is minimal risk of flight given the defendant's circumstances. The court is going to make the following order on bail. The defendant shall remain in her current hospital until medically cleared to be moved to a new facility. As a condition of bail, the defendant is ordered not to leave the hospital until discharged to a new facility. The defendant shall provide notice to probation 48 hours in advance of any transfer to a different facility. Based on the letter of the doctor, it would appear likely that she would be sent from the hospital setting to a 24/7 rehabilitation facility, like the Spalding Rehab. As a condition of bail, if sent to a 24/7 rehabilitation facility, she is ordered to remain in that facility, with the exception of if she needed to be transported to a different medical facility or a hospital for an additional MRI or something like that. The defendant shall continue to receive mental health treatment while hospitalized and sign releases for probation to monitor compliance with counseling. In the event that the defendant were to complete the services at a 24/7 rehab and complete that care, the court would hold a further hearing as to whether or not the defendant were in need of further mental health treatment that would need to be done in an inpatient setting, or whether or not the defendant's mental health care could be provided in a residential setting. The court would direct court clinician, court doctor, to consult with the defendant's mental health providers to conduct this evaluation at the appropriate time in the future. If the defendant were in a position that she was going to be discharged to a residential setting, both sides would have the opportunity to be heard further. Any discharge in a residential setting, the defendant would be subject to home confinement with appropriate electronic monitoring to monitor home detention. There would be exclusions that would be available if the defendant needed to attend medical or rehabilitation appointments, counseling sessions, or religious worship sessions. The court would have probation visit any proposed residential setting prior to the defendant being discharged to that type of a setting to ensure that such setting was appropriate and safe. The defendant is ordered to surrender her passport to probation. In the event that the defendant does not have a passport, she is prohibited from applying for a passport. The court is not going to set any monetary bail at this time.
Spectrum.
Ms. Clancy on docket 23.
Officers assigned to district number 4 respond to the area of the 2700 block of South 14th Street to check for a suspect wanted in a connection to a robbery that occurred yesterday at approximately 11:25 p.m. on the 3600 block of West Good Hope Road. Upon arrival, officers located a suspect who ignored the commands and fled on foot. One of the officers was able to catch up to the suspect and a struggle ensued. During the struggle, the suspect used a handgun and fired shots, striking the other officer. That officer discharged his firearm. During the exchange, the suspect was struck by gunfire. The officer, a 37-year-old male with over 4 years of service, sustained life-threatening injuries. He was transported to a local hospital for treatment. In spite of the best efforts of medical personnel, he died of his injuries. The suspect, a 19-year-old Milwaukee man, was pronounced deceased at the scene. At this time, it is unknown if the suspect's fatal injury was self-inflicted or from the officer's gunfire. This is a fluid and ongoing investigation. The Milwaukee area investigative team will be investigating this incident. The Brookfield Department will be a lead law enforcement agency in the investigation. A community briefing discussing this incident will be released in the future. Once family notification has been completed, we'll release the name and the photo of the officer. Milwaukee, our hearts are heavy. Milwaukee Police Department hearts are heavy. My heart is heavy. One of our finest who put on that uniform, put on that badge, went into work last night and paid the ultimate sacrifice for protecting our community. Milwaukee, we need your prayers. We need your support. To the men and women of the Milwaukee Police Department, I see you. I am proud of you. The work that you do not go unnoticed. And at this time, our community needs you. This is a time to lean in and do the work that needs to be done in our community. The violence needs to stop. The violence needs to stop. Everyone has a role in community protection. Men and women of the Milwaukee Police Department, please continue to support each other, support yourself. Families of our fine, noble, and dedicated men and women of the Milwaukee Police Department, friends of these noble and dedicated men and women of the Milwaukee Police Department, please check on them. Please continue to support them as we try to deal with this unfortunate tragedy. I thank you, and I'll now bring the Mayor, Cavalier Johnson, to the stage.
Thank you, Chief Norman. I'm here along with Chief Norman, along with as well County Council President Jose Perez and Office of Violence Prevention Director Ashanti Hamilton. And if you just heard Chief Norman, that passion, that concern, the heavy heart that he displayed just now, that's a representation of the men and women who every single day put on their badge and put on their boots and hit the streets to protect the people in this city each and every single day. Each and every single day. And as was mentioned, an officer paid the ultimate price